term, most people wouldn't
Yes.
know, you know? Like-
He obviously did not. Zero personal harm.
Looking at all these people. And I was up, like, cross-examining somebody. I turned around. I guess I just, I turned around. And the whole, everything was full of this whole different room. And I was so glad I hadn't even heard them.
You see, like, locked in and focused.
So I was like, going around looking for like important cases to take a picture. And I looked in the window and he's like, I was like looking at him and he was like, it must be really big. He's like, so it's a trespassing case. You looked like it was the trial of the century. I thought she was another term.
All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save the views of the United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. First off, I'd like to apologize for the temperature in the room. I've inquired about it. Should have been cooler for the parties and everybody else. It's not. We'll follow up on that. We have a hearing set today for the public defender to present argument or explanation of the motions you filed in these three cases. You may proceed.
Good afternoon, Your Honor. My name is Megan Long. I'm an assistant public defender here in the Second Judicial Circuit. Today, for the purposes of this hearing,
Can you bring that microphone down a little bit? Somehow the audio is not quite.
Is that better, Your Honor?
I think so. Thank you.
Good afternoon. Again, my name is Assistant Public Defender Megan Long. For the purposes of today's hearing on the outstanding motions, I'm acting as the designee for the Second Judicial Circuit. Your Honors,
So the public defender is aware of these motions, obviously, right?
Yes, Your Honor.
So she's authorized these motions to be filed in these cases?
Yes, Your Honor. Your Honor, according to the court's amended orders issued June 9th.
I'm sorry, Madam Clerk, has the clock started? Thank you. Go ahead.
Yes, Your Honor. According to the court's amended orders issued June 9th and today's docket, I'm aware there are 6 cases on the docket that I'm acting as the designee today. Unless the court would prefer otherwise, I would first like to address the 3 cases on the docket where the court has already denied the motion to supplement, and what is at issue today is a motion for extension of time. In the order that they appear on the docket, that would be James Blackman Jr., Tyler Smith, and Tabitha Tedder. So I would like to address the James Blackman Jr. case first. In this case, on Monday, June 5th, the proceedings in this court, or in the case, were stayed pending disposition of DuBose versus State. The motion for extension of time was unopposed, and it seeks to extend the time for filing the initial brief because this case is now stayed in the Florida Supreme Court.
Stayed because they're tag-along cases, and that's what the Supreme Court typically does in tag-along cases.
Correct, Your Honor.
They're not stayed in this court.
Correct, Your Honor. So the motion for extension of time, which again is unopposed, goes through the procedural history of, would the court like me to address the motion to suppress in this case as well, or just the motion for extension of time?
Just,
You may answer.
Yes, Your Honor.
can you just go right? I mean, we know the history. We know what's going on here. Can you just jump to the motions for extension of time?
Correct.
And in doing so, can you address what has been done to obtain the transcripts? What efforts have been made by the APDs that filed those motions to obtain the transcripts in those particular cases?
So in these 3 cases where the motion for extension of time has been filed, the first one is Escambia County. That is outside the Second Judicial Circuit. We would need a court order from the trial court to get that. And for example, I've called the Walton County court reporter myself because even in a case where the transcript was designated to the court reporter and included in the directions to the clerk, and it was supposed to be in the transcript and the record, and only one was at issue, unfortunately, it was not served to the court reporter, and so it was never in the record. It appeared as though the record were complete when we got it, but it wasn't. The Walton County court reporter has said, we need a court order from the trial court, even though it was supposed to be in there. And that's in Walton County. It's not in the Second Judicial Circuit.
Is that outside the state of Florida?
No, Your Honor.
I mean, the lawyers in your office are admitted to appear in all the courts of the state of Florida. So did someone from your office attempt to file a motion with the trial court to get that order?
No, Your Honor. We are outside of that particular county, and it needs to be, and we are now counsel of record, not the Escambia County Public Defender's Office. That's why we are moving to stay.
But you're appellate counsel.
I'm
right?
sorry, Your Honor?
But you're appellate counsel for
Correct.
the same defendant.
Correct.
And you're saying that the statute precludes the lawyers of your office from filing a motion in the trial court to obtain a transcript that is necessary for your appeal?
Yes, we cannot get it, Your Honor.
You can't get it because you think the statute precludes you from filing a motion in trial court to get an order for that transcript.
Your Honor, we have tried in DuBose itself, because that's outside the Second Judicial Circuit. That's in Alachua County. Transcripts for public defenders, for paid for out of that county's budget, that's for the 8th Judicial Circuit. It's not for the 2nd Judicial Circuit. And so
Did-
again, that is why we filed the motion to supplement with, in this case, a critical proceeding, a Nelson hearing.
Did anyone in your office file a motion in any of those courts, Escambia, Gainesville,
I
to
have,
ask for a court order for the publicly funded transcription of a proceeding that is needed?
we have asked a public defender in another county to file an order to get a transcript that is missing that was supposed to be in the record. I believe it will be granted, but again, that's outside the appellate rules. That's local counsel, and we've already been designated, and we cannot refuse a designation under this court's precedent now. So assuming that that gets filed,
I'm
assuming that
sorry,
that gets
if I can
granted.
just get an answer to the question, though. Has anyone from your office filed a motion in any of these courts for an order for a publicly funded transcription of a proceeding?
No, Your Honor. Our
why not?
No, Your Honor. Our APD, who filed depose under this court's order last Friday, after consultation with the Florida Bar Ethics Hotline, called and was told, because we are outside of the 8th Judicial Circuit, we cannot file one. It has
You
to come.
can't file a motion? You were told by a court, so, I mean, I read the Andrews brief. What it said in the brief was, what Ms. Lane said in the brief was, she checked with the court reporter, and the court reporter said they can't provide it outside for a PD outside the jurisdiction. That
Right.
doesn't answer the question of why a lawyer from your office can't file a motion to order
Because-
publicly funded transcription from the trial court.
Because we are on appeal now, Your Honor, and we're appellate counsel.
But
And
you're
so-
also a lawyer of the state of Florida.
And
you're
you're
a licensed-
representing the client. I certainly don't understand that answer. I've never seen a case where an appellate lawyer tells the court, oh, I'm sorry, I'm not allowed to interact with the trial counsel, I'm not allowed to file anything in the trial court. You're not prohibited by statute. It's not like you're trying to do a post-conviction case that you're not authorized to do. What it appears is the public defender does not want to follow DuBose. The DuBose decision laid out exactly how to proceed. Is it the position of the public defender that your office is prohibited by law from appearing in the 8th Circuit and in the 1st Circuit? By law?
From appearing as counsel,
From filing a motion in the trial court so you can comply with this court's precedent in DuBose?
yes, Your Honor, we're on appeal. Now,
Who
where in
files a
PD?
3800B motion?
3800B2?
Yeah.
This court, we do.
Okay. And where do you file that motion?
It's filed in the trial court under the very specific exception laid out in the rule, and then, of course, it goes back to trial counsel.
Sure. But that is, I guess your office does not consider that to be contrary to your statutory charge, right?
No, it's specifically set out in the rules of appellate procedure, Your Honor.
Right, which can override a statute. So presumably, you take the position that that rule is consistent with the statute, Chapter 27. I don't understand the distinction then. If you have the authority under statute to file a motion in a trial court as appellate counsel to obtain a certain end or in service of your duties on appeal, why can't you not file a motion to order transcription under the same?
Especially after we said in DuBose, that's precisely what you're supposed to do.
Judge Tannenbaum, if I understand your question, we are filing under a very limited Florida Rule of Criminal Procedure 3800B2, because that's under the appellate rules, and we file a separate motion in this court, letting the court know that we filed something in the trial court, and it's one of the exceptions, to correct a sentencing error for a judgment and sentence that is already on appeal. And I believe what the court is asking me is, can Assistant Public Defender Megan Long on appeal file a motion in another judicial circuit, in another county, outside of the appellate rules, to get a transcript for the appeal, regardless of who pays for it? And my answer to the court is no, Your Honor.
And what is your authority for taking that position?
The Florida Rules of Appellate Procedure.
Which override, I mean, you're saying that the absence of a rule authorizing your office to file a motion in a state court, that is your authority? The absence of a rule that authorizes it specifically is what precludes you from, as a member of the Florida Bar, from going into trial court in service of your duties as an appellate lawyer to file a motion to order publicly funded transcription of a proceeding that you think you may need to review in conjunction with your duties.
To answer your Honor's question specifically, we have in at least one case, but it is not this office. It is the office that is in that county. And again, I don't know yet. I don't know if that transcript will be added to and filed on CCIS, but we've attempted to. It goes outside the appellate rules, though, and I think even if I get it, I've been told by the court reporter it's going to be probably 6 weeks. And then if I get it, I can move to supplement as appellate counsel.
Yeah, which is exactly what we said in DuBose.
I believe the court said in DuBose we can go to any county and ask for a rough draft of transcripts. I've been told there are no rough drafts.
No,
There's
that
either
was,
a transcript.
That was one example.
Yes, Your Honor.
Pointing out one avenue that you can pursue in some circuits, including the 8th Judicial Circuit. But there's also always the avenue of just filing the motion, asking for a publicly funded transcription of a proceeding that you need, that your client is constitutionally entitled to.
Yes, Your Honor.
Because what it appears to be is a deliberate attempt to stall the process. In other words, rather than simply filing a motion in the 8th Circuit as a member of the Florida Bar, pursuant to DuBose, we're here on all these motions saying, oh, well, we can't do that. We want you, the First District Court of Appeal, to do it. When we said in DuBose, that's not how it works.
So, Your Honor, what I would say is to all 6 cases on this docket is we are officers of the court.
Right.
We can only file things in good faith, and whether it's...
Are you saying it would be in bad faith to file a motion in another circuit outside the territorial jurisdiction of the Second Circuit Public Defender to comply with DuBose?
If we know we can't get the transcript as appellate counsel...
What do you mean you can't get the transcript as appellate counsel? I don't understand. It's a standard motion. We see it 1,000 times. The motion to order transcription. My client is indigent. My client is entitled to publicly funded transcription in a proceeding.
Absolutely, Your Honor.
You know, cite 2525. I mean, it happens all the time. I don't understand what the lack of good faith basis is for filing that motion.
It does, and we see those too from our office and from the private attorneys who designate us. They ask for transcripts when they file their notice of appeal, but if something's missing, and in a lot of cases they are, after that record is transmitted, and if it's in another county, we can't get it.
Who's going to come in and say, you know, you can't do that? Like, let's say you filed a motion tomorrow. Let's just, as an example. You file a motion in the 8th Judicial Circuit, let's say in DuBose, motion to order publicly funded transcription of Nelson hearing, competency hearing, sentencing hearing, pointing out, look, these weren't transcribed originally, they weren't designated by the trial lawyer originally, but my client is entitled to, these are proceedings that are required by the rules to be transcribed publicly at public expense when requested, and you file that motion in the trial court. Who's going to tell you, I'm sorry, you're from the Second Judicial Circuit, you can't file that motion? Who's going to say that?
Do you think the circuit judge is going to say that?
I don't know, Your Honor, but I assume that it could be stricken because the case is on appeal.
Who would
and
move to strike it?
I don't know, Your Honor. We have never tried.
The Attorney General has basically taken no position on these motions, which I'm not sure why, because these cases aren't moving. They're not moving because of these motions. And at the very least, I'm startled why the public defender wouldn't at least say, I have sent a letter to the public defender or the counsel of record from the 8th Circuit saying, please, you must file this because I can't? Has that been done? Because I haven't seen it in the record.
So in DuBose itself, the attorney of record called and said, can I get this? Because we had to file that brief last Friday. We're outside the 8th Judicial Circuit, and the answer is no. They need a court order from a public defender there to get that
They need a
So
court
as the
order from
public
the court.
defender of the 8th Circuit refused to file that motion? I don't agree, from what I'm hearing from you, that there's any authority for your position. But assuming there is, for argument's sake, has the public defender for the 8th Judicial Circuit refused to file the motion?
We haven't asked them, Your Honor.
I didn't think so.
If I could go back to Your Honor's first point about are these motions filed in good faith? That includes the motions to supplement and the motions to stay. Your Honor, DuBose was pending motion for rehearing. It was not final when the majority of these motions were filed. I myself.
Is it your position that a decision of this court that is pending rehearing doesn't have to be followed?
No, Your Honor. What I am saying is it is not final, and it is currently at the Florida Supreme Court. And that's why we've moved to extend the 3 that I'm talking about right now, because they are tag cases, because
But
it has proven.
that court hasn't ordered these proceedings to be stayed.
That's correct,
These
Your Honor.
clients are not getting representation. These indigent defendants are not receiving representation. These briefs and these cases are not moving. Many of these clients, if not all of them, I assume, may be incarcerated. Their cases are not moving. I don't know why the Attorney General's office has not objected to these motions and attempted to get these cases moving. But that is an unjust act against these clients.
Your Honor, 2 years.
I assume you know that does not serve your clients.
Everything we do is to serve our clients, Your Honor.
Not allowing a case to linger and telling this court that you don't even file a letter to the public defender of the 8th Circuit saying, please, we're confused about DuBose. I'm not sure why you would be, but we're confused about DuBose. We don't think we have the statutory authority to represent our client in your circuit. Would you please file this motion? And if they refuse, if the public defender in the 8th Circuit refuses, bring that to our attention, because they are in our jurisdiction.
Your Honor, these were all filed in good faith. They're all unopposed. And
That doesn't
this-
mean they're in good faith. The fact that the Attorney General's office hasn't taken a position on it, which I don't understand, doesn't mean they're filed in good faith. Because the party suffering here is the defendant, whose case is not moving. If they have a colorable argument on appeal, if they have a winning argument on appeal, those arguments aren't being made.
I agree.
And I tell you, just speaking for myself, not for the panel, I don't understand it. I've been a judge on this court for 18 years. I worked for the Attorney General's office in criminal appeal. I've never seen this kind of procedure before. I've never seen an argument that I can't file a motion in the 8th Circuit. And you're stating as an officer of the court, this is a position of the elected public defender.
Your Honor, we have to file motions to supplement under the appellate rules to get our clients what they need. And we've done that. And we have to seek every.
Do you think these motions are in compliance with DuBose? Or is it your position that, well, hey, we're appealing DuBose in the Florida Supreme Court, so we're not going to follow DuBose. We're just going to continue to file motions to supplement.
Or put aside DuBose for a second and just talk about 9200F. I mean, there's no provision in 9200F, as we've discussed at length in DuBose, both opinions. There's no provision in 9200F that provides for this kind of procedure, where you ask the appellate court to order the trial court to order publicly funded transcription, nor is there a provision in the rule or in statute that allows us to order publicly funded transcription of a hearing. That is within the jurisdiction of the trial court, and the motion to supplement comes after you have transcript in hand and you've determined that you need it for your argument on appeal. What we haven't seen anywhere cited from your office is a statutory provision or a rule that precludes you or your office, a lawyer from your office, from going to the trial court to get these publicly funded transcripts. We haven't said that you're not entitled to them. We haven't said that you're not entitled to have them added to the record. But I don't think it is accurate to say that you're following the rule when you're filing the motions to supplement here.
So please allow me, I want to answer Judge Thomas's questions first, and then I'll go to you, Judge Tannenbaum. So Judge Thomas, we have to provide competent and zealous appellate representation to every client. Doesn't matter if it would be really hard to get the transcripts from somewhere. Doesn't matter if we think the trial attorney did a good job and there probably is any issue. Doesn't matter if it's the client's doing 1129 as versus someone who's doing PRR life. So for every single client who could be in the pipeline for relief or depose, for every single client who has a transcript that's missing, and I submit the motions to supplement in these cases, they're for critical hearings and they're for critical proceedings that we need. We can't say some clients, we're going to have some in the pipeline for relief, like the 3 that are stayed, and some that are not. We have to do our job to each and every single one under the appellate
I think
rules.
that's the point of these questions, which
Yes.
is why aren't you filing these motions in the circuit court? I'm well aware of the case law and the restrictions on the public defender's office. I'm quite familiar with the funding, with the operations, with the practice of the public defender's office. It's almost as if your argument is, we can't represent these clients, let's return these appeals to the circuit level.
Well,
Let's let 20 public defenders do their own appeals because, gosh, we're blocked. We can't go back there and file a motion in circuit court and get a transcript that this court said in depose you're probably entitled to. No one is going to block you in the circuit court. No one is going to say you're not a member of the Florida Bar. No circuit judge is going to deny it unless there's some grounds for which that transcript cannot be provided. I don't understand how DuBose could not be more clear on how to proceed.
Well, I respectfully disagree, Your Honor, that we are trying to make 20 assistant public defenders in a trial office do their own appeal. We're not filing a motion to refuse designations. Under Washington, of course, we can't.
But you're not filing the brief.
Of course.
You're not representing the client. You're not filing the brief in the case. You're not filing a letter to the public defender. If the public defender filed a motion in this court and said, I have written a letter to the public defender of the 8th Judicial Circuit, that public defender refuses to cooperate and file a motion to obtain these transcripts in compliance with DuBose. I don't think that's required, but for the sake of argument, let's assume the public defender did that. And that was filed in this court. You can rest assured this court would take a very close look at that and why that public defender is refusing to do that. This is serious business. These are clients, many of whom, as I said, are incarcerated, whose cases are not moving. And I don't see the authority for your position.
Well,
I haven't heard a reference to the statute that says the public defender of the 2nd Judicial Circuit who represents this client is not allowed to file a motion in the circuit court asking for transcripts. That is ludicrous on its face.
What I would say, Your Honor, is we are doing everything we can under the appellate rules and under the case law and under the way you get a case from here to the Florida Supreme Court to get these clients relief.
See, and I wanted to go back to that. So what I'm hearing from your answer is you don't like our opinions in DuBose. You disagree with them. I get it. But for, like, let's just say Mr. DuBose, just as one example. While you're off, tilting at these windmills and, these bigger projects, he's sitting in prison. He's not getting now he's got an Anders brief filed on his behalf with a reference like, hey, we couldn't get all the transcripts because of you guys, so you go get the transcripts. We're done. That's what we got on Friday in DuBose. And so Mr. DuBose is now continuing to sit, and we'll have to figure out what we're going to do with that. But I don't understand. So the position of the public defender is all the clients collectively are going to have to sit on ice and wait while you pursue a review in the Supreme Court of a procedural order regarding transcripts and whether an order has to come from us or whether you have to go file a motion in the trial court to get the transcripts done. Is that the position of the public defender?
Unless this court grants the motions to supplement.
So it's
And under the
basically like a
appellate
game of
rules-
chicken. It's like, look, we disagree with your order, we don't like it, so we're going to keep filing motions with you in every case until you relent. Or the Supreme Court takes jurisdiction, which is, I mean, is that the position, basically?
So the public defender has instructed you, and again, this is not specifically directed to you, but the public defender's position is that the lawyers in her office are not allowed to file a motion in the circuit court in the 8th and the 1st. Is that the position of the public defender?
We've called, Your Honor.
I didn't say called. I said, is it the position of the public defender of the Second Judicial Circuit that the lawyers in her office are not allowed to file a motion? Has she prohibited them from filing motions in the 8th and the 1st Circuit in compliance with DuBose?
No, Your Honor. Public
Why
Defender
aren't they
Yeary
filed?
has not
Then why aren't they
prohibited-
filed then?
Because we are complying with the appellate rules, and we've talked to the court reporter.
Which appellate rule? Can you cite specifically which appellate rule you're complying with by not filing a motion in the trial court to order publicly funded transcription of a proceeding?
The rule regarding supplementation, Your Honor, and as
That
you
rule
saw-
says nothing about a PD filing a motion in the trial court. Nothing. I've read it a lot of times,
Yes, Your Honor.
as you probably imagine. So which provision, it can't be in 9200F because it's not there. Do you have another provision in the appellate rules that precludes your office from filing a motion in the trial court?
Can we file a motion in the trial court? Yes, but we're specifically talking about transcripts. That's what Your Honor is referring to, a transcript for a case on appeal for which we have been designated for, and I assume we're talking about a case that is outside the Second Judicial Circuit in a county where we are not counsel anymore. We've been designated, and the court reporter needs a court order to transcribe whatever we're asking them to transcribe.
Yeah. You're representing, you have a client, you're representing them, you've been designated, that's your client. Now, when I was a public defender, I was taught we move mountains. I mean, we stop at nothing to achieve the objective for a client. Nothing. Be creative, do whatever you have to represent the client within your ethical obligations. So with that in mind, it seems like a simple matter of at least, it seems like a simple matter of filing a motion in the trial court. Maybe someone tells you no. Maybe the trial court strikes your motion, says you can't file this motion in my jurisdiction because you're the second Judicial Circuit. Well, then you'll know something, and then we have something that we can review, right?
I'm currently in the position of trying to get a motion filed by local counsel.
No.
I don't know yet, Your Honor. It's a brand-new procedure
Right,
that we've never done before.
But Ms. Lane has had maybe 7 or 8 months at this point. So in DuBose was filed, the motion to supplement was filed in October. And along comes this latest motion, and it sounds like, along with these other motions that we're talking about today, as if the PD's office has done nothing to try and obtain these transcripts.
Well, I would direct Your Honor, and Your Honor has said that you've read the brief filed on Friday. Ms. Lane laid out what she tried to do.
Yeah, she made a phone call, and then she called the bar ethics hotline.
Yes, Your Honor. And it's a lot of litigation to get all these cases in the pipeline for eventual relief, but we have to do it for each one of these
Eventual relief from the
clients.
Supreme Court. So this is all based on your mission of taking it to the Supreme Court, notwithstanding whatever is for the benefit of your individual clients.
All of our individual clients have to be in the pipeline for relief under the rules of appellate procedure. And I will note, we are special counsel now in the 5th DCA for the cases that we kept during the transition from the 1st DCA when we lost Duval, Nassau, and Clay counties. We represent our clients there the way we do here. If something's missing and we need it and it just wasn't in there, we file a motion to supplement, and it is granted. I myself, in this court, a few days before DuBose was issued, took over a case where the private attorney ordered pretty much everything except the sentencing hearing. And when I reviewed that record, I saw the judgment and sentence looks like it has an error on it. Looks like this client's serving an illegal sentence. The attorney filed a written motion for a downward departure sentence and also a written motion objecting to the PSI. And in that case, that client had been in custody. We need to know did the trial court orally pronounce all of the credit he was due? And also, does the client want us to challenge any fees? We can be held ineffective on appeal if we don't challenge those fees. We have been in one instance, at least that I know of. We need that sentencing transcript. I filed a motion for it explaining to this court why I needed it. It was granted a few days later. That was this year. I know I
Right,
need
but
it.
you routinely make those motions without knowing what's in them because you don't have the transcripts. And that's the point, is you're not obtaining the transcripts in advance and you're doing nothing to try and obtain those transcripts. So moving on to a separate line of inquiry, if this court or the 50CA were to grant one of these motions to supplement that you're,
That's what we're
as you've
asking
been
for, Your
requesting,
Honor.
who pays for that?
The county in which it originates.
Okay. So what is the difference between an order from this court and an order from the trial court doing the same thing?
It's on appeal here. It's not on appeal there.
No,
the
but I mean,
motion-
but like what you're saying is the only thing you need is a court order most of the time for it
Yes,
to be
Your Honor.
funded out of the JAC or the county funds or whatever else, all of which have due process budgets,
Yes, Your Honor.
including your office has a due process budget as well.
Yes.
I still don't understand the distinction then. You're relying on only the appellate rules, and you're saying the appellate rules preclude you or your office from filing a motion in the trial court to order publicly funded transcription, which your client's entitled to, and will be paid for out of some due process budget. Most of the time, either the county budget or the JAC.
Well, the appellate rules cover all proceedings on appeal where we are now. Now, in
No, the
DeBose-
appellate rules govern what happened here
Yes,
in
Your
this
Honor.
court,
Specifically
not
is-
what you do.
Specifically is to DeBose, when we are designated for appeal. And in DeBose, had we been able to get the transcript, and I think Your Honor has read the brief, you know we couldn't. Had we been able to get it.
No. It's not that you couldn't. You didn't want to try. You refused to try to get the transcript.
I respectfully disagree, Your Honor, but as to your point of payment, it would come out of that county's budget, because that's where the transcript is the cost sharing. Now, if Public Defender Uri had to pay for every single transcript in every one of these cases, we want that. We have due process funds, but this is in the 8th, and we're in the 2nd.
And the court reporter wouldn't accept a check from your office if you said, hey, we want to order it. Just like, let's say you're a private attorney. You call up you're here in Tallahassee and you've been hired to represent someone in Gainesville, and your client is indigent, so you're court appointed, but you're private. And you want a transcript. What do? You file a motion to trial court, and if your private counsel and the person's not indigent, you call the court reporter, they give you a bill, they tell you what it is, you have to pay half in advance, and you pay the other half after it's transcribed.
Yes, Your Honor, and before the record is transmitted, they pay for it. Or usually the client is found indigent on appeal, and it comes out of that county's budget.
But what happens, we're post-record transmission. Are you saying that the court reporter in Gainesville, for instance, would not accept a check from your office for payment of that transcript if he needed it?
I don't know, Your Honor. If it were an
'Cause you haven't
authorized,
tried. That's the point.
if it were an authorized motion and they would take our money, I'm sure they
What do you-
would. But
when you
again,
say
that's outside
authorized-
the rules of appellate procedure, and that's why we are taking DeBose to where we are. And
Do
I will-
the appellate rules govern the operations of the public defender? Or does Chapter 27 govern the operations of the public defender?
I believe what Your Honor is asking is, can we go to any court reporter in the state and any county and give them this statute and say, we need this, whoever pays for it, can we get it?
No, we're going to pay for it. My office has these funds, and I need this transcript. Please transcribe it and send me the bill.
Your Honor, as you saw in the brief in DeBose, because we're not in that county, the answer is no.
No, that's not what the brief said, and that's not what the answer is. What the answer was in that case was that the court reporter was not going to give the raw data, the raw transcript, or the CD for free, because you're not in that jurisdiction.
But it
We're not
applies
in
to
the-
the transcripts as well, Your Honor. The transcripts, well, there's no rough draft. There's either a transcript or there's an audio, because
Sure.
the rough draft, it would require manpower to
And you could order it. You could order that transcript, yes?
No, the
You
Eighth
could
Circuit
not,
could.
you could not call the court reporter in the 8th Judicial Circuit this afternoon and say, I'd like to order the transcription of, name the hearing, sentencing hearing in, one of these cases. The court reporter would say, I'm sorry, I don't know you.
So-
I'm going to refuse to transcribe
Your Honor,
that.
for me, is Megan Long calling up and saying, can I
Yeah.
get that? As long as I pay the fee. As a public defender, we need that court order from the 8th Judicial Circuit for them to transcribe it. Then we need the court order.
Your
and someone pays
boss,
for
the
it.
elected public defender of the Second Judicial Circuit, needs a court order to pay for, out of her
We-
budget.
We
the
need a court
transcript?
order to get the transcript, Your Honor. We can't just call and ask for it.
No, I'm asking, am I not asking it the right way? If you wanted your office to pay for it out of your budget, your position is, or the elected public defender's position is that she needs a court order before she can expend due process dollars out of her budget?
Yes, Your Honor, we need a court order to get the transcripts, whether it's,
I guess one thing that's becoming clear in this hearing is it is the position of the public defender of the Second Judicial Circuit that that office is going to challenge DuBose continually in all these cases. The public defender is not going to file any motions in the circuit court seeking, if you're right, and you need a court order, assuming that's correct. Apparently Judge Tannenbaum is not sure that's correct, but assume that it is, and a court reporter would refuse a call from the public defender with money in hand to get the transcript. Your position is that you have to have a court order from the 8th Judicial Circuit, for example, in a case from the 8th. You're challenging our decision in DuBose. You're tagging these cases. Until that time comes, you're not going to file a motion in the 8th Judicial Circuit, nor have I seen a letter requesting the public defender of that circuit to do so to obtain the transcript. You're not going to do it. That's
Your Honor,
that's your position.
we don't have jurisdiction.
I know. You're not going to do it, correct? You're
Correct,
not
Your
going to
Honor.
get those transcripts for your clients.
We're trying to, under the appellate rules,
How
Your
are you
Honor.
trying to?
We're filing these motions to supplement in
It
this
sounds
court
like you're
under the
trying
appellate
to by
rules.
challenging our decision in the Supreme Court, which is your right.
Yes,
You're
Your Honor.
free to do that. You're not free to do, what you're not free to do is to refuse to file a motion in the circuit court, obtain a transcript, so that your client's cases can proceed in this court. You're not free to do that. It appears to me. I don't see anything in Chapter 27 precluding your office from doing that.
Your Honor, we cannot, under this court's precedent, refuse.
What precedent?
I'm sorry, refuse a designation. We can't do it.
I know you're designated. That's why I'm asking.
Yes.
You're representing your clients.
And before-
Your obligation is to represent them zealously and timely.
I couldn't agree more,
But
Your
the
Honor.
position of your office is, we're not going to get those transcripts. We're going to allow these cases to linger until we get a ruling, hopefully, from the Florida Supreme Court that our ruling in DuBose is incorrect. That's your position.
Yes, Your
I
Honor.
mean, the public defender's position.
Yes, Your Honor.
Are you able to cite a provision in Chapter 27 that supports your position?
I
Is
would
there
cite
a
to the.
single provision in the part of Chapter 27 that governs public defenders that says you or an APD in your office may not file, as an appellate, let's just say an appellate APD, may not file a motion outside of that public defender's jurisdiction?
Here, the only motion we're talking about is a motion for transcripts.
A motion to order the publicly funded transcription of a hearing
This your client's entitled
to which
By
your client
law.
is entitled to by law.
by law.
Your Honors, I have 6 minutes and 47 seconds.
You don't have to use it all if you don't want to, but as long as you're standing here, we're going to keep talking to you.
Well-
Apparently, we're not getting very far, but I think it is clear that the position of your office is You're not going to represent your clients in any circuit outside of the second, even though they're entitled to these transcripts at no expense to them by law. That's the position of the public defender.
Your Honor, everything we have done in these 6 cases on the docket is to get these clients what they need on appeal. And I know Your Honors have looked at the motions we filed. They've been timely. We haven't taken extensions of time in most of these before we moved to supplement to get what we needed. And just earlier this year, I did the same thing with one of my clients, with the last one I needed to supplement. Every one of these clients, every one of them needs relief, and we have to do everything we can in our power to get them relief under the appellate rules, and because they are stayed, 3 of them in the Florida Supreme Court, the ones I was originally going to address. The other ones, I submit this court can grant those motions today under the rules of appellate procedure. And when that motion to supplement was granted, we'd be served with it. It would only probably take less than a couple weeks. Before DuBose and before Washington, we would often receive cases from other circuits. You know, now the case is on appeal. We'd often get cases where it's missing, where it's incomplete, where we just don't have what we need to do our jobs. We used to refuse those designations. So jurisdiction goes back to that local public defender, back to that county to get what we need, because as soon as we get designated, that's when the clock starts ticking for that initial brief. And the example that I spoke about previously with Judge Tannenbaum, something that was supposed to be in the record wasn't. Just through an error, just through a mistake that happens all the time, where a court reporter wasn't served. So
Have you informed your clients
yes, Your
that
Honor.
you are not obtaining these transcripts?
Our client,
And that
I
you have-
can't go into specific.
I'm sorry?
I can't go into specific client conversations, obviously, but obviously our clients were informed about everything we're doing.
So they've been informed that because the First District Court of Appeal has directed that we must go back to the trial court to get the transcripts, we're not going to do that because, as you say, we're prohibited by the Florida Rules of Appellate Procedure.
Your
I
Honor,
submit that. I
again,
submit that's incorrect. But having said that, have you informed your clients that therefore their cases cannot proceed?
Your Honor, again, without going into specific client
Do
communications.
they know their
with-
cases are stalled?
Do they know their cases have motions to supplement and are stayed or have motions for extension of time? Yes, Your Honor. We inform our clients what we're doing at every stage. Beyond that, I can't comment on any confidential client communications about these 6
And you
specific
have, and the
appeals.
public defender has not entered a written communication to the public defender of the 8th or the 1st demanding that they file these motions, or at least requesting that these transcripts be, these matters be transcribed. I didn't see a written communication.
It's on appeal now, Your Honor. In
What's on
terms of
appeal?
all these cases. Now, in terms of
failure-
what has our public defender communicated with the public defenders who designated us, Public Defender Yeary has told them, make sure you get everything up front. Make sure when that private attorney moves to withdraw at that sentencing hearing that they filed everything they need to file. Sometimes it doesn't happen. Double check and make sure before the record is prepared. Double check and make sure before we are designated and become appellate counsel. Get it all done when the notice of appeal is filed. Public Defender Yeary and I personally have called up and said, don't designate us. Make sure you get it right, but when the record is being
It
transmitted.
sounds like an argument for the legislature to consider designating all 20 public defenders to do their own appeals. Because what you're describing is essentially a procedural nightmare. You're not going to follow DuBose. I understand you have a right to appeal DuBose. You've done that. But what you're describing is some kind of odd bifurcated system whereby once you're designated, you cannot go back to that circuit, and therefore the client suffers.
With the time I have left, Your Honor, I do think it is worth noting, assuming the Florida Supreme Court does not accept jurisdiction on DuBose, assuming that's the end of the line, and all these cases that are stayed there, those are lifted, and the only way to obtain records is going outside of the appellate rules. What is going to happen is, if we are designated, because now we're counsel now on appeal, what's going to happen is we're going to have to get these transcripts or someone gets these transcripts, whether it's PD8, PD14, whether it is us. Assuming if we say this is now the law, or if we file a writ and say we need to have these. But assuming they now have to be gotten outside of the appellate rules, which would be different than all the other district courts of appeal in Florida, what's going to happen is...
We're not bound by the other district courts of appeal.
Yes, Your Honor. Yes, Your Honor.
They're free to make incorrect rulings.
Yes, Your Honor. But what I would suggest to the court is what is going to happen is the second we get designated, that's when this clerk adds Public Defender Uri as a party, and that's when our clock starts running. That's why ACES was such a big disruption for our office, because we couldn't see the cases from the EDCA to ACES transition. But as soon as we are designated, the clock starts running the 30 days for that brief. And assuming we are timely finding what we need to be transcribed, going outside of the appellate rules, it could very well mean by the time we get transcripts in hand, that time to file the brief is over. We've taken 60 days of stipulated extension, assuming that administrative order stays in place. The time to file the brief, we will have to contact Tricia Meggs Pate and say, we're waiting on these transcripts that are outside the appellate rules, because unlike a motion to supplement, that's not going to toll time. We're going to have to extend this
And for the
case.
record, maybe the other district courts are correct, and the Florida Supreme Court is going to hold that we're incorrect, and that you're prohibited from filing a motion in the circuit and requesting a copy of these transcripts. Your time's expired.
Thank you, Judge.
We'll take a 5-minute recess. Court's in recess.
All rise.
We have the second case on the docket, Swift Response versus Root. Is the petitioner ready to proceed?
Thank you. May it please the court, I'm Sylvia Walbolt from Carlton Fields. With me at council table is Matt Canigliera. He's going to assist me if I am unable to hear. I'm very severely hearing impaired, so I may turn to him to help me if I don't understand. We'd like to reserve 5 minutes.
Yes.
And I'd like to start by answering the question that the court posed in its order setting this hearing, which is to say, yes, this court has jurisdiction even if the trial court was not asserted to have violated a Florida Supreme Court decision. And there are a number of decisions that we believe establish that proposition pretty clearly. The Rodriguez case in 2013 of the Florida Supreme Court held that the threshold jurisdictional requirement for a writ of cert is irreparable harm. And this court has similarly held that that's the jurisdictional requirement in a number of decisions. The DeSantis decision in 2020, People's Trust in 2022, and most recently in statewide guardian ad litem this year. Then, in order to grant the petition on the merits, then the court turns to the issue of whether the trial judge departed from the essential requirements of the law. But that's not a jurisdictional requirement. That's the merits of the petition. And to the extent this court, in framing the question, was asking whether a district court decision can be clearly established law if it's not Florida Supreme Court precedent, but rather is a DCA decision. Again, the answer is yes. Under Caclamanis, and we can file the cites with the court after this hearing if that would be helpful. The Florida Supreme Court said that clearly established law includes controlling case law involving the same issue of law, and under Pardo, the Florida Supreme Court again held that decisions represent the law of Florida, decisions of the District Court of Appeal constitute the law of Florida unless and until they are overruled.
Don't those decisions, I mean, to the extent that there is a decision that comes out of the Supreme Court or a DCA, it's not the opinion itself that's the law, it's the law that's being interpreted that's the law. Is that not correct?
No, it's the decision, but usually the decision is reflected by the terms of the opinion, and the opinion is going to explain what is the law that's controlling the decision.
Right. I mean, well, I'm sorry, when I said decision, I mean the opinion. But the opinion is just evidence or a reflection of what the law is. You know, it's the legislature that makes the law in the state of Florida. It's the Constitution that is the law of the state of Florida, not what we say, not what the Supreme Court says. So when we talk about decisions or opinions being part of the law, or even in the Supreme Court decisions talking about it, isn't what the Supreme Court really saying is that to the extent that the Supreme Court or one of the DCAs interprets or applies either a statute or the Constitution, that has the force of law with respect to the law itself.
With respect to the issue that's being presented by the case.
Right.
Yeah, and so we believe that answers the question, yes, that when the issue is one of law for the court to decide, the decision of a district court is going to be the established law on that issue unless and until it's overruled by the Florida Supreme Court.
Sure. But in the context of discovery, what is the law being applied?
When is the law? The law is being applied by the trial judge on the motion that is before it.
Sure, but what is the law itself? I mean, if the law is the Constitution and the statutes in the state of Florida.
Well, the discovery comes from a variety of sources. It comes from the rules. To some extent, it may come from statutes. But the issue that is presented in this case is one that has been developed by the courts over many, many years. And that is the test for when a plaintiff in a products case is entitled to obtain discovery with respect to products that are different, that are not the same as a product that allegedly injured him. And that is a test that has been developed by the courts over many, many years to implement the requirements of the discovery rules, that discovery is only to be allowed if it relates to the injury caused. And so that's the kind of the predicate. Most of these cases that deal with the requirement of substantial similarity look back to that initial predicate of that discovery is, in a products case, is only going to be allowed if it is connected to the actual injury from the product used by the plaintiff. I hope I've answered the question. I find sometimes I answer questions that weren't asked, so just try it again. But I think just following up on your question, the case law issue here for us, and I'm sure you're going to hear this from my opponent, is the extent to which, when it's a question of a discovery order, what is a jurisdiction over discovery, certiorari jurisdiction over discovery orders. And the Florida Supreme Court came out with a case a couple of years ago called Internal Improvement, in which it held that the mere allegation or even showing of overbreadth of discovery was not in itself sufficient to show irreparable harm and thus insufficient to show jurisdiction. But in holding that, it didn't say there never can be jurisdiction, certiorari jurisdiction to address a discovery order. It specifically adhered to its earlier decision in a case called Langston, in which they said all we're saying is that overbreadth alone is not sufficient to automatically create irreparable harm.
Right.
But then the court went on to say, and if I could just finish it because this is important, the court went on to say that having said that a litigant is not entitled to carte blanche discovery and that certiorari is appropriate where discovery is allowed, quote, even when it has been affirmatively established that such discovery was not legally relevant. And we think this case squarely fits within that test because the issue here is one that's very common to products cases. And over the years, the courts have, as I said earlier, the courts have developed a legal test for when they're going to allow discovery, not just with respect to the product that the plaintiff actually used and says was defective, but earlier products, earlier models, and the like. And they've imposed the burden on the plaintiff to come forward with evidence that the other products or the earlier models of the same product that they are seeking discovery on, that in order to get that discovery, they have to show that those earlier models or other products are substantially similar with respect to the matters that are alleged to be negligent, to be defective. And here the plaintiff made no attempt to show that. The plaintiff presented an argument that basically said nothing more than the can looks the same from the outside and it's got the same name on it, so it's the same product. The defendant came forward then with considerable scientific evidence that several years before the product that this plaintiff used was manufactured several years earlier, the design and the specifications had been dramatically modified, specifically with respect to the components within the can and the valve, which is what was alleged to be negligently designed and defective.
What is the actual harm, though, to your client for having to produce? And I should ask first: has your client produced documents in response to the discovery request? I know that it was mentioned in the petition that there was a response to discovery, but were documents actually produced in this case?
Your Honor, that we think the actual harm to our client is considerable, and it's both substantive and it's procedural. And the first harm to us is if this test cannot be enforced against a trial judge who hasn't applied it properly, it's never going to be enforced. The production of the materials will have been made. There's no way to get them back. They're now a matter of public domain.
But they're not trade secrets, right? I mean, there's not been a claim of trade secret in this case. Is that correct?
We would contend, Your Honor, that they involved not only trade secrets, but sensitive business information. It's certainly information that is not publicly usually available, not information we would like our competitors to have. And I would urge this court to read the discovery requests that we're talking about, and I think you'll understand the harm. They're extremely broad, going back for more than a decade, and it shows the evolution of this particular product and how it was changed so dramatically in 2019 with respect to the precise parts of the product that are alleged to be
But isn't that reasonably calculated to lead to relevant evidence if the prior products?
Your Honor, the courts, the answer I would say is no. The courts have over the years said it's not reasonably likely. Remember, it's got to be likely, not just is there some chance out there. It's not reasonably likely to lead to relevant evidence. They made that determination as a matter of law where there's no similarity between them. If you've changed...
But this was the same, this was Flex Clear. This was limited to Flex Seal Clear. Isn't it possible or likely or reasonably calculated that, again, I'm not suggesting this happened, but the allegation that your client changed the product to the detriment of safety?
Well, the evidence is clear. We changed the product, and we changed the product with respect to the precise aspects of the product that are alleged to have been negligent.
But I mean, I don't know what the plaintiff's theory is going to be at trial to a great extent, but I assume the argument is going to be, in some sense, that your client either negligently or purposely changed the product for a cheaper manufacturing process that endangered public safety.
The reason that we changed the product, Judge, should never come in. The question is irrelevant, and I would say, if anything, the change favors
But what if the prior
the manufacturer who has
what if the prior manifestations of the product were more safe and your client made it less safe in order to reduce costs or whatever, isn't that relevant?
There's not
Or
a,
reasonably calculated to be
not a
relevant?
shred of evidence.
I understand you're not conceding that. I'm asking you, could that be relevant?
But we presented evidence that it was changed to address these components that are alleged to be negligently designed. The plaintiff presented no evidence at all. The plaintiff didn't make any of these arguments. The plaintiff's argument was the can looks the same from the outside and it's got the same name on it. That's the end of the inquiry. And I submit to you that is not the end of the inquiry under settled case law that has been developed over many years to address this precise issue. And how fast it goes. And just to conclude, again, I want to emphasize that these are questions maybe you get to with respect to the merits, but they don't go to the jurisdictional issue of whether there's irreparable harm, which there is, not only because we can't undo this production, but because it's going to impact the rest of the proceeding, because now the manufacturer is going to have to be defending prior products and why, and explaining prior claims. Thank you, Your Honor.
Thank you.
One more question added to the.
Just wait to rebuttal. Sorry.
May it please the court, Rebecca Creed on behalf of the plaintiff. With me is Nick McNamara. With regard to the question that was posed, we would agree that the two prongs going to irreparable harm are technically the jurisdictional requirements. But as to the failure to show that this trial court's order departs from clearly established law, that is a requirement of certiorari relief, and certainly this court can and should decline to grant certiorari where there has been no showing of a departure from the clearly established requirements.
Yes, I mean, it appears, at least to me, on the surface at least, this is why we're having an argument, that if a court has certiorari jurisdiction every time a discovery order is challenged based on relevance, which seems to me to be the argument here, then that's just unlimited. And every single discovery order, whether it be over breadth or relevance, is going to trigger our jurisdiction, and obviously the focus order addresses that.
Yes, and that's clearly not the intent under the Florida Rules of Appellate Procedure, which narrowly define the categories of non-final orders that can be appealed, and also the Florida Supreme Court's jurisdiction, particularly as most recently stated in a case we cite, State versus Garcia, which addresses
I'm
the
aware of
limited
Garcia
nature.
where they said even a criminal defendant cannot obtain certiorari jurisdiction to protest turning over a phone passcode, which could result in a conviction in his imprisonment.
Correct.
His remedy is on direct appeal.
Yes.
We actually said something very similar in a case we wrote. But, yeah, if a criminal defendant cannot trigger an appellate court certiorari jurisdiction, where if you play out the possibility in Garcia and in the case we had, that defendant must turn over the passcode. The passcode can be used to produce evidence, obtain evidence used against that defendant. That defendant can be convicted and sentenced to life imprisonment. He may or may not qualify for a supersedious bond. He will then be imprisoned pending appeal, which can take years.
Yes.
Occasionally, and thus that's not irreparable harm. So how is it irreparable harm when there's no specific allegation of trade secret or some other substantive privilege in any discovery order, not just yours?
So then I think our case does not even address the confidentiality and the trade secret and attorney-client privilege issues because those were never brought to the trial court's attention.
So it seems the argument of the petitioner is it's somehow fundamentally unfair for us to have to defend a prior manifestation of the product. product. Is that, am I missing
That's
something?
correct, and I would like to make a couple of points
But it's
related
not
to
even
that.
defended. They're not being asked to defend a product. They're just being asked to produce some,
Correct.
documentation
Yes.
with respect to a product. Right? I mean,
Right.
there's a
And
difference.
we are here on discovery. And I would like to point out that the characterization of the case law as controlling and clearly established precedent is inaccurate, as we point out in our response. In no case, even though cited by this defendant, has an appellate court required the showing of substantial similarity with regard to the same product that is at issue, the same product that allegedly caused the harm that is here. And here the product is Flex Seal Clear. And the only requirement for showing substantial similarity is, as set forth in the cases they cite with the Alvarez v. Cooper tire case. It starts with the broad scope of the discovery rule. In product liability actions, when a plaintiff seeks discovery regarding other products manufactured, Florida courts have uniformly held that the other products must be substantially similar to the subject product, citing Nissan Motors v. Espinosa American Medical Systems, Caterpillar Inc. Versus Keskes. And so there is no showing here that we're not seeking discovery related to another product. We're seeking discovery related to the very product that is at issue here, which is Flex Seal Clear. There are other types of products under the Flex Seal name. There's a Flex Seal tape, there's Flex Seal Black, there's Flex Seal White, but it is very clear that we're only seeking discovery related to this product at issue. The
But on the-
petitioners, excuse me.
On the question of jurisdiction, though, so the Supreme Court has expressed concern or sensitivity in other contexts, recognizing that we are a court of limited jurisdiction in some ways. We typically only get to review final orders, and as you know, and everyone knows here, and orders, non-final orders that are enumerated in 9130 and a couple other spots in the appellate rules. Other than that, we don't have jurisdiction to review orders. And that's what makes certiorari so extraordinary, is that it's really an end run around our jurisdictional limitations. And the Supreme Court has shown sensitivity to that in other cases, including like motions to dismiss and those kinds of things, because there's not a limiting criterion with respect to that. If we start looking at motions to dismiss for a variety of reasons, it's unduly burdensome to have to defend against this whole case when we know, that maybe it's not entirely meritorious. So in the context of discovery, what would be the limiting criterion that we would apply to not have cert be used all the time to review discovery orders, orders compelling discovery, when the party on the receiving end of that order doesn't like it, thinks that it's just too broad, and then tying it up and tying this court up for a while.
Well, I think the framework that has been established, where it is likely to lead to a cat out of the bag type of evidence,
Which is trade secrets. So
information.
a substantive right is at stake in those situations. Statutory privileges,
Yes.
trade secrets, that kind of thing.
Yes.
That's one.
And
That's
here,
one criterion.
There was an argument made about trade secret information. Certainly, the trial court just today entered the written order denying the motion to stay and setting forth the requirements for the production of a privilege log. So the petitioner will have an opportunity to identify any privileges that it seeks. And so, again, there's opportunity to protect against the disclosure of trade secret information or the disclosure of confidential business information. We're not even there yet. I mean, we have not, this discovery was served in November of 2021. There have been no documents produced.
If we dismiss the cert, let's crystallize this a little bit more. If we issued an order dismissing the cert petition on the ground that the petition seeks review based on overbreadth or something along those lines, and that we don't have jurisdiction, there's not a limiting jurisdictional principle for that, we don't have jurisdiction to consider such petitions unlimited that not tied to a trade secret or some other statutory right. Would that be conflicting with any Supreme Court decision that you're aware of?
I do think it, as I understand it, which is the same as Ms. Walbold, in that the two prongs, the irreparable harm go to the jurisdiction, the departure from clearly established requirements is to the merits, and so, well, I think
Yeah, hold
certainly-
aside I'm not talking about the departure
Right.
from the essential requirements. I'm just talking about material injury that can be
Okay.
remedied on direct appeal.
If there's no material injury because there's been no identified harm or reparable harm
Which
that you
is
can't correct.
invariably is tied to the idea of like a trade, the cat out of the bag type of stuff. Like if you don't have a statutory right of some sort that you can't get back at the end, if that's not present and it's just man, it's going to be like a train car or 5 train cars worth of documents that we're going to have to cull through and produce. That's the only harm, so to speak. Is there anything from the Supreme Court that precludes us from saying or dismissing the petition on the basis like that assertion on its own can't be irreparable harm to support jurisdiction in cert?
I don't believe that's inconsistent. I think that's very consistent with the Board of Internal Improvement Trust Fund case, which stated that overbreadth can't be a measure for granting cert relief. And here, the argument that there is somehow some legal irrelevancy to the documents that we are seeking and that the judge has ordered carte blanche discovery is plainly not borne out by the narrowly tailored relief that the judge has granted, specifically related to this product, but also completely distinguishable from the cases they rely on in an attempt to show that somehow this discovery is legally irrelevant, which were the 2 public slip and fall cases and a case involving a charging lien where it wasn't even related to the litigation below. This is not a case where the discovery that's sought is legally irrelevant. It's plainly irrelevant to our causes of action, which are strict liability and negligent failure to warn and products liability claims.
But just for the sake of argument, their position is that you're trying to, again, I'm not endorsing it or rejecting it out of hand, but their position is that the products you're attempting to discover are not the product that caused the alleged injury. So therefore, it cannot be reasonably calculated to lead to admissible evidence.
We disagree with that assertion. First,
Well, how is it how is it reasonably calculated to lead to admissible evidence?
because we have alleged that there was both strict liability and that this defendant released highly dangerous products without adequate warning and instructions, and that if, as Your Honor pointed out, if the evidence was that in an attempt to make this product less flammable, in fact, it made it more flammable, then that would go to show that this product was unreasonably dangerous, and that the evidence would be directly relevant to the plaintiff's claims.
Counsel for petitioner, responded to my questions along these lines by saying, well, you didn't make these arguments below. I'm not going into preservation, I'm just asking questions about, so what is your burden, do you think, below regarding obtaining this discovery? Because counsel for petitioner said it's your burden to show evidence, which I'm not sure how you show evidence when you don't have the discovery, but go ahead.
Yes, how can we show it's if we don't have the evidence to show? I would disagree with her characterization of what we argued below. She seems to suggest that just because we showed a can that was related, that was the same product, that somehow we said, oh, it's all about the appearance of this can. And that's not accurate. The reason we didn't argue substantial similarity is because we weren't seeking discovery related to other models, other makes, and other models. We were seeking discovery related to the very same product that is alleged to be an issue in the complaint, which is the Flex Seal Clear. And so we had no obligation to come in and show substantial similarity, as demonstrated by the language of the Alvarez case, citing these other cases. And there's been no Florida case law that requires the level of specification that the defendant seems to suggest here, which is that not only do we have to show it's the same product that's at issue, that we have to show it was manufactured according to the same specifications during the same time period. And that is nowhere found in these cases. And in fact, I would point this court to the Caterpillar versus Keskets case, which is relied on by Nissan versus Espinosa and also the American Medical Systems cases. And in that case, in the Caterpillar case, it related to incident reports from a tip-over of a forklift. And while the appellate court, under the overbreadth analysis, which would subsequently, as we know, would not be upheld now, but even in that case, although the 5th TCA, I think it was, found that there was no relevance, no showing of substantial similarity with regard to 73 other different models in the forklift, the court did specifically allow 5 years' worth of incident reports going back to the time that that particular model of forklift first was made up until the date of the incident. And so that goes to show that there's been no limitation with a requirement that we have to show that the same product that our plaintiff used was made to the exact same specifications, and that we're only entitled to discovery related to the post-2019 changes. That level of specificity and requirement does not exist in the case law. Again, the only need to show substantial similarity is when you're seeking information related to other products, other makes and models.
Do you think go ahead, I'm sorry.
That all goes to the merits.
Yes.
Getting back to the jurisdictional question here, there seems to be, it's an artificial distinction between the jurisdictional elements, if you want to call it that, and the departure from the essential requirements of law element. Because, in a way, if there's not an essential requirement of law that's been departed from, it's harder to argue what the irreparable harm might be. Like, again, using the cat out of the bag, that's an easy situation because you have an actual statute, some legal right, some substantive right that's being violated that you can point to. You can say, well, the court departed from that, and it's a miscarriage of justice, which is the other aspect of this, sort of the overarching consideration here. It's a prerogative writ. Here we're talking about it's purely procedural. The discovery rules are purely procedural, at least typical civil discovery. We're not talking about a statutory right to discovery. I'm just talking about like this kind of discovery we're talking about here is purely procedural. You don't have a right to discovery, and presumably you don't have a right to refuse discovery unless it violates some other right or something like that. So in this instance, trying to square all of this together, when it's overbreadth, which it seems like they're arguing, that's the harm. How do we consider that and consider whether there's been a miscarriage of justice if we don't have an essential requirement of law in the first place that's being departed from, other than a discovery rule, which is procedural? That was a very long one. No periods or commas in any of that, but do the best you can.
I think the Florida Supreme Court's decision in Garcia is helpful because even though as Your Honors have pointed out, there was a suggestion that by ordering to disclose this passcode, it would lead to all sorts of problems for that particular criminal defendant at trial. But even there was not irreparable harm incapable of remedy. There was availability.
That's what I was going to ask, actually, is Is Garcia a sea change? I don't understand how any purported violation of a discovery rule, other than a statutory right to trade secret or some other privilege, can now ever invoke an appellate court's jurisdiction. If a criminal defendant can go to prison under a life sentence and his only remedy is on direct appeal, how can a mere civil corporate defendant or any other civil defendant or civil petitioner ever have a right to invoke an appellate court's jurisdiction if the argument is based on a very narrow, substantive right, such as trade secret?
Well, I think trade secret's different from overbreadth. I mean.
Oh, I know.
I'm
I'm asking does Garcia indicate a real sea change in your opinion?
I don't believe so. I think it's consistent with a lot of Florida Supreme Court case law. I mean, it certainly cites to and considers a lot of Florida Supreme Court case law, including, Combs and Martin Johnson versus Savage. I think, it's just an evidence of the limited view that the Florida Supreme Court takes of the ability to seek certiorari relief. And here, just like in Garcia, this defendant would have an opportunity to seek relief on post-judgment appeal or final appeal should we get to questions of admissibility, not discoverability.
In fact, wouldn't the harm only occur if you obtain this information and it's improperly admitted at trial? That's the harm, right?
That's the harm, and I think otherwise there are certainly protections to prevent against the disclosure of trade secret, violation of confidentiality.
And I'm glad you brought up Savage. Just to touch on that a little bit, I'm having a hard time understanding if we were to accept jurisdiction even in this type of cert petition, and I don't know what the legal principle that we could come up with as a limiting principle that wouldn't conflict or be inconsistent with what the Supreme Court said in Savage, for instance. Can you think of a way to reconcile that?
I have not.
I mean, it's what I brought up before. They've
Right.
expressed concern, like how do we limit this and keep it from, in keeping cert from eating the jurisdictional limitations of the DCAs? And it seems like a cert petition like this that's claiming almost entirely just overbreadth as a basis for relief, corporations make that objection in every single civil case. I'm guilty of it myself when I was representing corporations. Is there a limiting principle in this? And I think that's one of the
Right.
fundamental questions here.
Well, I mean, I think you can go back to Board of Internal Improvement and say overbreadth is not. I mean, that's a limiting principle from the Florida Supreme Court, that overbreadth is not a basis for demonstrating irreparable harm. And it is under Allstate and the other cases addressing the cat out of the bag where there's disclosure of confidential or protected privileged information that could then be led to injure, I mean, in the sense of harming someone if that information is disclosed. Those are your principles. But here, I agree with you. It is almost entirely overbreadth with some issue as to confidentiality that will be remedied by this trial court's subsequent order. So we would ask this court to dismiss or deny the cert petition. Thank you.
Thank you. Madam Clerk, would you please add 2 minutes to the petitioner's time? Thank you.
Start with Judge Tannenbaum's question, which I think several of the questions went to, and I suggest that the limits on your certiorari jurisdiction is already established. It's established by the Supreme Court in Internal Improvement and in Langston, and it sets forth the test for expressly sets forth a test of when certiorari jurisdiction is appropriate in discovery orders that grant carte blanche, which this does. All models of this product since they've been manufactured for more than a decade, and I suggest those limitations are what this court should apply, and I remind the court that the second and the fourth have both, since internal improvement, cited Langston, followed Langston, applied it in determining that they had certiorari jurisdiction to quash discovery orders. Those were slip and fall cases, and the discovery was being
Sure.
sought in prior stores and
But what-
other stores and the
but what
like.
is
But
the-
that, I
what-
suggest, gives you the test that you need.
What is the substantive right, so constitutional right, statutory right, that your client has that's being invaded such that this order compelling discovery, it violates that, and it will result in a miscarriage of justice? Miscarriage of justice.
It has a right to be free from discovery about products that have not been shown to be substantially similar with respect to the matters that are at issue in the case, and that it is the plaintiff's burden, not my burden, to come and show that they're not substantially similar. We did, but it's the plaintiff's burden, and we've been deprived of that procedural right to have the plaintiff be required to come forward with evidence that this is not substantial, that they are substantially similar.
But which provision of the Constitution or which statutory provision gives your client that right?
I'm sorry, Your Honor, just have to bear with me. It's just, I can't point to that. You have lots of rights that aren't in the Constitution. It's a right that is established by the law that was binding on this trial judge.
But isn't it just an interpretation? I mean, again, going back to my point before, I mean, discovery is purely procedural, is a creature of the courts, and only the creature of the courts. And so, in assuming that courts don't have the authority to create rights out of whole cloth, which is substantive law, where would this idea, this right to be free from onerous discovery, overbroad discovery, where does that come from?
That we have a right even under, it comes from the discovery rules, and it comes from the established case law that the trial judge was bound to follow. And if I could, because I know I'm running out of time, I want to make sure, Judge Thomas, you understand, there's been plenty of discovery about the prior models. The plaintiff knows exactly how the prior models were designed and knows their specifications, and we've not suggested they can't get into discovery about that. What we've said was that the discovery requests here will go far, far beyond that, including all lawsuits, all claims that have ever been filed with respect to any of these models. And as to the contention that they're the same product, that's the identical argument that was made in the second district's decision that the fourth followed in the Osborne case. Is the identical issue that this is just the same product, it's just different models of the same product. And the second and the fourth both quashed the discovery and exercised their certiorari jurisdiction. Judge Tannenbaum, you said that the certiorari is an end run around the appeal, and obviously to some extent it is, but it's also a safety net. And it's a safety net for when there's no way to correct an error on appeal. And once this production is made, it can't be undone. And we can't have the right to have the plaintiff carry the burden that the courts have just for years and years said is their burden to get this discovered.
But what is the inherent harm in producing records, some of which may not be used, some of it may not be entirely relevant? the quote, getting it back, doesn't apply the same way as like a trade secret. A trade secret loses its nature as a trade secret once it becomes public, and that right then is eviscerated, and you can't get that back on appeal. It sounds like it's still, we come back to the same question. It sounds like the harm here, or the burden, or the irreparable harm that you can't get back on appeal is the inconvenience of going through voluminous records and producing them, calling through them to identify attorney-client privilege, trade secrets, and that kind of thing.
I come back to the burden of proof because that is a substantive right that we've been deprived of, and then that's usually considered irreparable harm. All I can say, Judge, is the second and the fourth have both found, easily found irreparable harm where a defendant is required to make a massive production of very sensitive business things they hold confidential, things that would be useful to competitors to know, and now they're being required to produce them without any showing that it has any relevance whatsoever to the actual product that's alleged to have injured the plaintiff. Thank you.
Thank you for your time. Thank you both for your arguments. The court is in recess.
All rise.